All right, let's begin here at the South. The Section 194 inquiry into Public Protector Advocate Busua Mkhwebane's fitness to hold office continues in Parliament. Yesterday, the inquiry heard from Advocate Leboane Chiwalure, who worked in the Public Protector's office. He worked on several reports, including the much talked about South African Reserve Bank investigation, which started while Mkhwebane's predecessor, Professor Thuli Madonsela, was in office. He testified that he received an email from Mkhwebane to conduct further research into the state ownership of central banks in other countries, and says he did not understand why, but there's more that he also said. Let's explore this now with legal analyst Mpumelelo Zikalala. Thank you so much for your time, Kuzeni. How serious is this issue of the changes that he claims were made to the CX report, looking at the fact that this forms part of, what the committee is looking at when it comes to deciding whether or not she's fit to hold office?
Good evening to you, Mangat, and also the SABC viewers. It is very serious if the changes that were made have altered or provided a report which is inaccurate, a report which at the end of the day would have led to different results or results which are not true and accurate being provided by the Public Protector's Office. Let's remember, yes, she does have the power to alter whatever report that is there. The rules are there. They give her that particular power. Also, the Public Protector's Act in terms of investigation also allows her to do that. But the most important thing is that it must be warranted. There must be merits to the amendments or to the changes which are going to be made. So if you are going to make changes which are going to alter the ultimate result, tipping the scales into something which is not true and accurate, well, some may even move to say in defense or in the pursuit of a certain narrative, then definitely the Public Protector has failed in her duties. Why is that important? Let's remember what the Constitution says in terms of the various grounds of misconduct in which the Public Protector can be charged for as per Section 194, which is your misconduct, your incapacity, or the inability to conduct yourself in a manner in which a fit and proper person would be able to do.
Now, listening to what you're saying, then the witness talks about a difference of opinion between himself and Advocate Thuli Madonsela, who is the former public protector. This is about the recovery of the money in relation to the Bancorp bailout. He says he believed it was right to recover the monies, but Madonsela didn't seem to think that this was possible. And Mkhwebane then comes into office, agrees with him that these monies should be recovered. Listening then to what you're saying about these changes, does that then have some sort of bearing to sway the inquiry in some kind of direction here?
It may have that particular bearing, but the inquiry will also need to be persuaded by an expert who's going to come in and say, if I were to look at this particular matter and the merits and the facts which are before you as the committee, as an independent legal analyst or independent legal expert, I would have certainly come to the conclusion which is opposite or different that of the Public Protector. So in that case, based on what was there and what the law actually says, this is how or things should have been done. Let's also remember that there's also a case which has been decided on the matter. So if the basis of the decision of that particular matter dealt with this particular point in which the inquiry is currently debating or mulling, at the end of the day, the conclusion would be, look at what the court has said. The court has made an order saying that certain things didn't go correctly, supporting the instigations or the allegations that in the conducting of that particular investigation, the Public Protector didn't observe the clear legal frameworks which are available to her, dealing with instances of misconduct and also maybe in a few instances incompetence. Then the committee has all the powers and ammunition to say, Public Protector, you have failed in your duties, you're incompetent in the manner in which you conducted this particular investigation. We can't have you occupying this office when you're going to commit mistakes such as these ones. What usually happens, if in an institution there's a difference of opinion as to whether something is wrong, correct, or right, especially within the legal framework, which is why we have, for example, legal practitioners which are going to be outside of the institution, and we would say to them, please go and write an opinion. I need a legal opinion on this particular matter so that we can be able to discuss it. Even if you send it to 3 or more people and those legal practitioners come back with different opinions, it is up to you to then say, this is what I'm going to go with. If I go to court, I know that I'm going to win, or the prospect of success are more if I have an opinion which is similar to this one. But what matters the most is that in the manner of conducting that investigation, because you know the importance of the office that you occupy as a public protector, you must make absolutely sure that you've covered all your instances, you've done your research, you've consulted as extensively as possible, so that at the end of the day, it is authentic that the mistake that you would have made is one that could have been made by anyone, not one where you have information available to you and you deliberately chose not to accept it on the basis that you want your own narrative to be pushed out into the public.
It's going to be interesting then to see how this one plays out, because this is one of those contentious reports, as we saw even with the Fredia Dairy Farm, for example, where there were also claims and counter-claims there of names being removed and all of that. But I'm also keen to hear your thoughts on this one before we wrap up, that, you know, her lawyers are still adamant that the president must come before the inquiry to give evidence, and they still say that they, you know, do believe that he does have some questions to answer to here. What is the likelihood of all of this?
They are very slim. The most important question is, what is the president going to go to the inquiry to do or to answer? At the end of the day, the inquiry is limited to these 3 points, or 2 points, as stated earlier. It is instances of misconduct, it is instances of incompetence. So if the president is not going to testify pertaining to those 2 things, then the president is not really a witness in this particular matter. Secondly, the president is also going to be a decision maker at a later stage after the National Assembly has dealt with the matter. If the public protector loses in this particular inquiry, or this particular inquiry committee comes back and says, indeed, all the allegations which have been leveled against the public protector are correct. So it would not be wise from a procedural point of view to call the president at this stage, who's also going to be a decision maker at the end of the day. So what the inquiry should limit itself to is all the witnesses which are going to assist in terms of proving or not proving that the public protector engaged in acts of misconduct, or that the public protector is incompetent or is competent in conducting a job. Anything other than that is not going to help the inquiry at all, and in fact is going to blur sort of the procedure and cause certain irregularities which are going to take place. And if this matter were to move to a court in the next occasion, definitely the court would say, you have messed up this procedure, it's not supposed to go in this particular matter.
It's going to be interesting to see how all of this continues to play out. And this is not the last, I mean, listening to the proceedings even today, that we hear of this Absa Bancorp report. But let's speak again soon as we see then whether or not, you know, which side these scales are tipping towards. Thank you so much for your time. That is legal analyst Mpumelelo Zikalala.